what we call it. I've also calculated that in mind.
Right. Yeah, that's the app. So maybe you can set a limit. Mr. Erickson suggested money. So can also have those of the first respondent.
My Lord, Monday is when we are getting the document.
Two more days.
Yeah. What we are saying, we frame issues and then we don't scale. Because where we have agreed funds. Agreed funds. Document. After or
File in additional affidavits by Thursday, 8th of May. For the second respondent, file the same as the taken by Monday. By Monday, the 5th of May.
My Lord, if you need to make any repayments, we can do so in the next 3 days by Saturday. Colleagues 5, the respondents by 8th. I will request for 2 more days to see if there are any rejoinders to make. They are deficits. They are not. No matter, I'll say that I'm done with activities in support of the petition, but when they respond, I may need to rejoin some aspects. Because now they may raise.
Put a limit. You say you have finished filing, so let them file and
My Lord, I'll request that if they raise new matters in their affidavits, further first they are filing in reply to mine. File depositions purportedly retracting the evidence already made in support of the petition. My Lord, we would like to raise, I don't know now or at a time opportune that the court may give us, a preliminary objection. Those affidavits be struck. Lord, if you permit me, I can make the objection now or at any other time that you may allow me. If not now, my Lord, my request is that my colleagues or the first respondent stop practice for approaching our witnesses and getting affidavits from them when they have already given us affidavits. With me, my Lord, I can make the picture now. Come on back. different decisions, but authorities of this court and the court of appeal that we have uphold that practice. And the court of appeal has severally, more than 10 times, punished both the deponents and the advocates for breakup. I don't know which scripts you're reading from. The decisions we have. So my lord, if you allow me, and my colleagues are ready to argue the people, we argue it now. We see their decisions, we see ours. Oblige my lord.
Where's the interpretation? Can't business.
I'm obliged, my lord. Again, it's 3 affidavits filed by first responder. These are the affidavits of Chamber Nathan Mwamuzi, the affidavit of Mawumbe George William, Maziga. Chamber Nathan Mwamuzi. Second affidavit, my lord, is that of Mawumbe George William. And third is that of Ben Hassan Kali. My lord, Chamber Nathan and Mawumbe George, on the 9th of April, 2025, saw affidavits in support of the petition. Saw affidavits in support of the petition, which we filed in court. Chamber Nathan and Mawumbe George William saw affidavits in support of the petition, which we filed in court and serve upon respondents. So affidavits in support of the first respondent's answer to the petition. Saying, my lord, that conduct of approaching our witnesses, and making them recant our evidence is unlawful. Detestable, my lord. It is contrary to Rule 19 of the Advocates' Professional Conduct Regulations. My lord, it means that those affidavits were obtained illegally, and this court and the court of appeal have frowned upon that kind of conduct. Why? Because it rebels against the tenets of the NDA. My lord, the courts have held that if the first respondent found any issue with our affidavits, the course of action would be to wait for those witnesses in court and challenge their testimony by way of. My lord, the first case I have is Chintu Alex Brandon versus Ekifo Commission and William Moses. What about you? Chintu Alex Brandon versus EC and William Moses.
You have copies for me?
I have one, my lord, after reading it, I'll give it to you. Versus Electoral Commission and William Moses. I'll just read the holding, part of the holding of the Court of Appeal. It was held there, my lord, that we wish to point out that the actions of the second respondent and his legal team in approaching the witnesses of the petition and obtaining affidavits from them was contrary to Rule 19, which not only renders counsel involved in disciplinary proceedings for professional misconduct, but ought to be sufficient ground for rejecting and striking out those affidavits for violating the tenets of a fair trial. our rules would have required that the challenge to such evidence would only be by way of cross-examination to test the veracity of the evidence. An adverse side, my lord, is prohibited from approaching witnesses for the other party with a view to induce them to testify against that other party. Versus Joseph Casoro, Okero, and his. My lord, there. My lord, here the court of appeal. In our view, it is imperative that actions taken in total disregard of the law must be sanctioned. The law ought to be struck out. The land trial judge ought to have struck out the second set of 12 affidavits sworn by persons who had already. The case of Nalukoola, Hussein Hanifa, Nalukoola Hussein Hanifa versus Usasira Peace Kembi and his. Nalukoola Hussein Hanifa versus Usasira say that you have the power, my lord, to punish my colleagues here now for that. My lord, in view of those brief arguments and the authorities I have relied on, I pray first that the affidavits of Chamber Nathan Wanguzi, Naumbe Jojo William, and Ben Mukasa be struck off the record of court. 2, my lord, order my colleagues for the first respondent for respondents have done in all of those authorities. They strike out the second set and leave the other one. And then by you, my lord, the court of appeal say that if that set remains, then the court subjects them to a prohibited test during cross examination. But the second set of affidavits goes.
Because the first bit deals to the punishment, and we had not prepared. So my lord, to punish all these lawyers, would request that I excluded the rules. So my lord excluded the punishment with request for time, because we have authority laws, which including the presidential petition, where we have had.
Not only that, you shouldn't focus so much on the punishment. Focus on the first. The rest of this was about striking out the second segment.
Yeah, my lord,
So don't get lost.
he has already exculpated us. He has said they were approached by the guy who committed the crime. But at the same time, he was saying he would cancel for the first time in practice is beginning to collect witnesses. Now, if counsel is to approach or has been approaching witnesses, that changes the whole process. As far as I know, counsel does not approach witnesses approach to, and he has also said they were brought by Italian, and that is why they want to punish Italian. But at the same time, he wants us.
So the players for time.
For time.
Time you prepare your reply.
Yeah. If we can do it written or we can come back.
I think you come back and come back tomorrow.
Tomorrow is
No, Thursday, Friday. Friday. Friday will be second.
Yes.
Tomorrow is the first.
Every Monday. Friday we already have
My lord, I am passing 10 lawyers. All of them cannot have it.
But
Let's come and dispose
they
of
all have the same.
Let's dispose of that matter on Friday, my lord. Start next week, finally. Let's come back and handle it on Friday. I was saying that.
So it's not, and yes, it's passing many lawyers. However, there are also repercussions on each of them individually with the prayer. So we're going to request for man and marriage to be accommodated.
The issue of whether we proceed by way of athletics is now settled. Whether we should, because my lord, the last time round of elections, what we are saying, we can proceed Liverpool, replace someone, that kind of things. But I think because we have all now filed affidavits, I think we assume that we have agreed to proceed with this petition by way of athletics.
I don't understand.
Monday, 5th of May, 9 a.m.
When you visit for 9 months, don't do it in a minute. And it also means that you want
That's a soko de makati. That's what Nalukoola
The trial process in the election petition filed by the NRM through their candidate Nambi has commenced today, with all preliminaries, pleadings and responses are in. But the respondent, Honorable Nalukoola, could not proceed today with the matter since he has not yet been supplied with the necessary materials from the Electoral Commission. Perpetrator of violence want to depend on the same violence to impeach an election in the perpetrator's favor. The perpetrator of destroying election materials, ballots and the like, wants to use the same to defeat the voice of the people. So it will be an interesting matter. Luckily enough, the coerced witnesses to provide evidence to the petitioner have since jumped ship by coming to give us evidence, retracting their forced evidence. That is an issue now for trial, and on Monday we are coming to determine how you treat such evidence of people who claim they were forced to provide evidence in support of the petition. So that is going to be a new twist in this matter on how such evidence is treated. That is why this matter has been adjourned to Monday for this court to determine on how to deal with evidence of people who are saying we were coerced to provide evidence by the petitioner. And they came to us saying we want to retract our evidence. That will be the only interesting bit on Monday. After that, we shall proceed with trial. the respondents given a chance to look at the election materials that we requested for, we'll also be ready to proceed. We don't see it as a serious matter, and we pray this court will really find reasons to dismiss the petition.
Council, is Monday for ruling or making your submissions?
Monday we are arguing out the matter. The petitioners have made a case of their petitioners having, their witnesses having recanted the evidence. We do not believe witnesses would come to us to say we are forced to give.
Twetaaga okuteekayo obujulizi bw'abantu abalala 6 ate nga tulina n'obujulizi bwe twasaba mu kakiiko k'ebyokulonda bwe tutannafuna okuli ne declaration of result forms eza polling station ezo mukyala Nambi zagambibwa okuba nti yawangula 12. Twagala ne register y'akakiiko konna n'ebirala ebyakozesebwa mu kulonda twabisabye era twabisasulidde era tubirinze babituwe ate nga twagala byesigamako mu musango gwaffe. N'akakiiko ebyokulonda nako kasabye nti kalina abajulizi abalala 6 be kagenda okuleeta, so kooti netugamba nti netuwe weekend na namba okulaba nga tuteekamu obujulizi obwo mu biyita mu birayiro ebyo. Wabula abawaabi ne baddamu ne bateekayo okusaba nga bw'omanyi nti omusango guno twabagamba dda nti gwa mankyolo. Kati olw'okuba abajulizi abamu be baakozesa ate bamba ne bagamba abamu beegaana n'okwegaana obujulizi bwabwe nti afe tubukolangako. Kati ekyo ne kibanyiiza nnyo ne bagamba nti ate lwaki abajulizi baffe mwabatuukirira, ate lwaki baawa obujulizi nga bwegaana obwaffe. So ne tuteekayo okusaba nga tugamba nti waliwo emisango gya kooti ekigamba nti omujulizi ekyaso kikkirizibwa. So kooti netuwa olunaku lwa bbalaza okukomawo wano twogere kuttaanya ku nsonga eyo oba obujulizi obwo obw'abantu abagamba nti baakakibwa oba byali bya bulimba biri bye baateekayo nga beegaana bye baakola mukyala Nambi yateekayo oba bukkirizibwa oba nedda. So ekyo ekigenda okubeerawo ku Mande ssaawa 3 naye ate nga tukyalina obudde wiiki namba okuteekayo obujulizi obulala fembi abaawaabirwa. So tujja kukomawo wano ate tulabe kooti kyesalawo n'okutulungamya paka omusango guno gunaagobebwa ate batusasule. Ekyo tugenda kyanukula kubanga tugenda kyanukula kunaku lwa bbalaza. Ndowooza olw'okuba ennaku zino bawulira nti General Court Marshal esiba balooya, kaakati baagala ndowooza ne kooti eno enkulu naye ekozesebwe okusiba balooya, naye tujja kukyanukula.
Omusango gw'ebyokulonda teguba gwaffe. Ensobi gyalowooza nti abo abajulizi babe. Musango gw'ebyokulonda mu mateeka ebeera investigation kuba kunoonyereza. Buli bujulizi bwonna obusobola okujja mu maaso ga kooti buleetebwa. Kyekimu bwe bumu kw'obwo obujulizi omuntu bw'aba agamba nti bankozesa ekirayiro nga bankase. Olw'okuba kuno kunoonyereza, kooti nabo erina obutunuulira esalewo nti ono ddala Nambi yamukaka okumuwa obujulizi oba nedda. Kati ekyo puliida talina waayingiriramu. Naye nakyo tulidde okwewozaako okusalawo okulaba nti nno tukakasa kooti nti erina okuwuliriza ensonda zonna. Oli agezaako kunyigiriza bujulizi bwaffe obuddamu obujulizi bwe. Naye omukisa oguliwo mu election petitions obuvunaanyizibwa bubwe okuwa obujulizi obulaga nti akalulu kakola ki tekatambula bulungi. Bagambye looya abadde clear omu ku bajulizi be ye yagamba bajulizi banne nitugende tukole ki era yabaleeta si balooya, kibadde very clear. N'ekirala omujulizi ayinza obutajja mu kooti. Cross examination ebeera ku mujulizi azze mu kooti. Obuvunaanyizibwa obuyita omujulizi mu kooti si bwaffe bwa kooti. Oyinza n'okusaba okuleeta omujulizi eyo kooti neekola ki neegaana. N'ekirala mwe mulistinga nti bano tubaagala obabuuza bano tubeetaaga. Oyinza okwesanga omuntu atajja mu kooti. Oyo omuntu bw'atajja mu kooti kitegeeza obujulizi bwe bwonna bugibwa ki mu kooti. Oba tofunye mukisa mu cross examining.
Okay.
And for us to retract their statements.
Okay. Okay. Now, we have informed the court this morning that the first respondent, Honorable Elias Nalukoola, and his lawyers engaged themselves in the illegal practice of approaching our witnesses and enticing them, I don't know in whatever fashion, to retract the evidence that they gave the petitioner, Nambi Farida, in support of the petition. The evidence that they purportedly retracted has to do with bribery. In other words, they wanted our witnesses who have given clear evidence of bribery, okay, to retract their evidence, okay, or their testimonies. Now, under the law, that conduct is illegal. You do not approach the witnesses of the other side and ask them to give you evidence in support of your case. The court, we have told, is that when you do that, the second set of affidavits that you have brought to retract the evidence should be removed from the record of court because those affidavits would have been obtained illegally. We are asking ourselves, why did Honorable Nalukoola and his lawyers attempt to retract our evidence of bribery? Is it not proof, therefore, that Nalukoola bribed voters during the course of the election? Because if you do not fear what my witnesses are saying, why do you not wait for them during cross-examination? Why do you go and buy them? Why do you go and entice them? Why do you go and force them? It is proof that what they are saying you are scared of and you don't want them to say in court. Unfortunately for them, that conduct the court cannot allow it. The Court of Appeal has decided many times that when that happens, the second set of affidavits is removed and our affidavits remain. And they are free thereafter, the first respondent, to cross-examine our witnesses with regard to the allegations of bribery. So for us, we feel that Nalukoola is scared of bribery, okay? He's scared of bribery, and it is clear proof. If he can buy witnesses in court, and he does not fear to buy witnesses in court, how will he have feared to buy voters down in the constituency if you can buy witnesses who are already before court, okay? What would have stopped you from buying voters down in the constituency? So we have told the court that that is illegal, and prayed, one, that those affidavits be struck out of the record of court and our affidavits remain. Second, that the lawyers who have participated in this kind of conduct be punished, because the Court of Appeal has severally punished lawyers who do such kind of things. You approach other witnesses, the court has said they punish you there and then, which punishment is in the discretion of the court, or majority of the times what the court has done is to send lawyers who are engaged in that kind of conduct to the law council for punishment. Mu Luganda olwaleero kooti tugibuulidde nti Nalukoola ne balooya be beenyigidde mu kugulirira abajulizi baffe. Bwe twateekayo petition eno, Nalukoola ne balooya be twagibawa basobole okugiddamu ng'etteeka bwe ligamba. Bwe twagibawa kye baakola mu kifo ky'okuddamu petition n'ensonga ez'omuggundu kye baakola ate kugenda ku bajulizi baffe kubagula kubajja ku sayidi yaffe kubateeka ku sayidi yaabwe. Abajulizi bano be twogerako be balina obujulizi obumu obuluma Nalukoola ku nsonga y'okugulirira abalonzi. So aba witnesses abo babiri babatuukirira ne babakozesa ebirayiro mbu nga bajjawo obujulizi baali batuwadde obuluma Nalukoola mbu nga beegaana obujulizi obwo tebwabukola. Ekintu ekyo kikyamu, kooti ejulirwamu n'ensukkulumu emirundi n'emirundi zikiganye nti kanso takkirizibwa, kandidate yawangula takkirizibwa kutuukirira bajulizi be sayidi eri. Ffe twebuuza, bw'abeera nga Nalukoola alina obuvumu obugula abajulizi abali mu maaso ga kooti nga tatidde tafunyeemu wadde enkenyera, n'ogula abajulizi abali mu kooti n'obakyusisa obujulizi, onaagamba otya kooti nti abalonzi ba wansi eri ku kyalo tewabagula? Bannange Nalukoola agula, Nalukoola agulirira era mumwegendereze. Kooti tugibuulidde nti omusajja agulirira ba witnesses baffe era emuyimirize ne balooya be abali mu mbeera eyo ey'okubanga batuukirira aba witnesses baffe, kooti ebabonereze era ebayimirize. Ensonga eno kooti egenda gisalawo ku Monday obanga ebirayiro Nalukoola byagula bijjiwa ku rekodi ya kooti oba okusigalako. The role of the third person, Ben Mukasantale, was that he is the one who went to the field, collected these witnesses and took them to Nalukoola and his lawyers. These affidavits I'm talking about were actually drafted by the law firm of Nalukoola and company advocates. That Nalukoola was fully aware that these witnesses have come and they are purportedly recanting our evidence. Kalule Ahmed Mukasa.
Yes, amanya Sari Isaac Keith, ndi mu kibiina kya National Unity Platform. Lwaliro tuzze wano ku Twin Tower okulaba omusango gwa Honorable Nalukoola eyalondebwa MP w'e Kawempe nga yawaabibwa omukyala Nambi owa NRM. Naye kyannaku nnyo nti nno olwaleero ttiimu ya Nambi esabye omulamuzi nti babonereze ba lawyers ba Nalukoola mbu batandise okugulirira abantu baabwe olwa abasobola okuwa obujulizi. Naye tusaba NRM wamu ne mukyala Nambi okuswala baswaleko okwo. Okusooka akalulu kano kunnyini baakabba bo kunnyini wadde akalulu kabalemerera naye baakabba. Akalulu kabangi nnyo olw'okuba nti n'abantu balonda nga bamanyi kye baagala. Ne bakola fujjo lyonna ne bakola akalulu bakubye bannamawulire bakubye ba agency bakoze biki otunulira ne polling station ezimu almost results twazifuna naye ate still ate bazze ku honorable omulonde ate batandise n'okutta erinnya lye kugamba olaba nti waliwo obuswavu era guno omusango nze neewuunya ne judiciary yani badde guno omusango egugoba prematurely kubanga tegukyalina gesture yonna otunuulira abalawyers baffe bali very set era nga nze nsuubira nti mukyala Nambi yandibadde yeewummuzaako n'aba nga alinda oluusi okwesimba kuba baffe gye biri LC1 asobola okwesimba ku LC1 bwa kansala asobola okubwesimbako nebino ebifo ddala ebyenkizo byasooka byesonyiwe nti kubanga kati akasente keyandibadde asevinga kati ate agenda kukawa bannamateeka ba Nalukoola kati kugamba olabya ddala ebintu by'okuswala n'olwekyo ndowooza mukyala Nambi za amagezi genkuwa weewummuzeeko actually osobola n'okusaba omulamuzi nti omusango okome wano kubanga mutuufu tegukyalina lugendo gye gulaga.